I woke up at 4:30 in the morning to the sound of my rooster crowing, just like I had for the past 3 years since buying my property in rural Lancaster County, Pennsylvania. The pre-dawn darkness was still thick outside my bedroom window, but I was already pulling on my work boots and heading downstairs to start my morning routine on my small farm. Little did I know that this ordinary Tuesday would mark the beginning of a legal battle that would consume the next 6 months of my life, and expose just how far a power-hungry HOA president would go to impose her will on everyone around her. My name is Harrison Fletcher, and I had moved to this property after retiring early from my corporate job in Philadelphia. At 42, I had saved enough money to buy 5 acres of land that was technically within the boundaries of the Meadowbrook Springs development, though my parcel sat at the far edge where the manicured lawns gave way to agricultural land. The previous owner had been farming this land for decades, and I had continued the tradition, raising chickens, goats, and maintaining a large vegetable garden that supplied most of my food and provided extra income at the local farmers market. I walked out to the chicken coop, my breath visible in the cold March air. The hens were already stirring, clucking softly as I filled their feeders and collected the fresh eggs. My goats bleated their morning greetings as I moved to their pen, and I spent the next hour doing the essential work that any farmer knows cannot wait. Animals do not care about convenient schedules or what time the sun comes up. They need to be fed, watered, and cared for when they need it, not when it is convenient for neighbors who prefer to sleep until 7. The sun was just beginning to paint the eastern horizon with streaks of orange and pink when I heard a car door slam. I looked up from mucking out the goat pen to see a silver Mercedes SUV parked in my driveway, and a woman in pristine white pants and a designer sweater marching toward me with a clipboard clutched in her manicured hands. Her blonde hair was styled in that particular way that screamed expensive salon, and her face was already twisted into an expression of disapproval. "Excuse me," she called out, her voice sharp enough to cut glass. "Are you the owner of this property?" I leaned my pitchfork against the fence and walked toward her, wiping my hands on my work jeans. "I am. Harrison Fletcher. Can I help you?" "I am Brenda Morrison, president of the Meadowbrook Springs Homeowners Association," she announced, as if the title should make me bow or curtsy. "I have received multiple complaints about the noise coming from your property in the early morning hours. This is completely unacceptable." I frowned, genuinely confused. "What noise are you talking about?" She gestured dramatically toward my animals. "This. All of this. Your rooster crowing at ungodly hours, your goats making noise, and you banging around out here before 5 in the morning. Residents have a right to peaceful enjoyment of their homes, and you are disturbing that peace. Mrs. Morrison, I have been doing this same routine for 3 years, I said, keeping my voice calm and measured. No one has ever complained before. Well, people are complaining now, she snapped. And as HOA president, it is my responsibility to ensure that all residents comply with our community standards. I am officially notifying you that you must cease all farming activities before 7 in the morning. That includes animal care, equipment use, and any other noise-generating activities. I stared at her, trying to process what she was saying. You want me to not feed my animals until 7. That is not how farming works. Animals need care on a schedule, not when it is convenient. Then perhaps you should not have animals, Brenda said, her tone dripping with condescension. This is a residential community, not a barnyard. I suggest you find appropriate homes for your livestock and convert this property to something more suitable for our neighborhood. My temper, which I usually kept well under control, started to rise. This property was farmland before your development was even built. I have every right to continue the agricultural use that has existed here for over 50 years. You have the rights that our HOA covenants grant you, Brenda countered. And those covenants include provisions about noise, nuisances, and activities that negatively impact property values. I will be sending you an official notice today. You have 1 week to comply, or we will begin fining you $500 per day. She turned on her heel and marched back to her Mercedes before I could formulate a response. I watched her drive away, my mind racing. I had reviewed the HOA documents carefully before buying this property, and while my land was technically within the development boundaries, it was specifically designated as agricultural in the county zoning records. I had assumed that meant I was protected, but clearly, Brenda Morrison had other ideas. I finished my morning work in a dark mood, then went inside to shower and make breakfast. While eating scrambled eggs from my own hens, I pulled up the HOA documents on my laptop and started reading through them again. The covenants did mention noise restrictions, but they were vague and seemed primarily aimed at things like loud parties or construction work. There was nothing specific about farming activities, and there was a clause that stated the covenants would not supersede local zoning regulations. Around 9, I called the county zoning office and explained my situation. The clerk I spoke with confirmed that my property was indeed zoned agricultural and had been for decades. She told me that agricultural zoning in Pennsylvania came with specific protections under the state's Right to Farm Act, which was designed to protect farmers from nuisance complaints as long as they were following standard agricultural practices. So an HOA cannot just tell me to stop farming. I asked. They can try, the clerk said with a chuckle, but they do not have the legal authority to override state agricultural protections. I would recommend you contact a lawyer if they are serious about pursuing this. I thanked her and hung up, feeling slightly better. But the good mood did not last long. That afternoon, a courier delivered a thick envelope containing an official notice from the Meadowbrook Springs HOA. The document was full of legal language, but the message was clear. I was in violation of community standards. I needed to cease all early morning farming activities immediately, and if I did not comply within 7 days, I would be fined $500 per day. Additionally, the HOA reserved the right to place a lien on my property for unpaid fines. I read through the notice 3 times, my anger building with each pass. The document cited specific dates and times when residents had allegedly been disturbed by noise from my property. What struck me as odd was that all the complaints had apparently been filed in the past 2 weeks. For 3 years, no one had said a word to me about noise. Most of my neighbors were friendly and had even complimented my farm fresh eggs. So what had changed? The next morning, I woke up at my usual time and went about my normal routine, though I will admit I was more conscious of the noise I was making. I tried to be quieter with the metal feed buckets, and I even considered whether my rooster was really that loud. But the reality was that farms make noise. Animals make noise. That is simply part of agricultural life, and it was absurd to expect complete silence from a working farm. Around 8, after I had finished my morning chores, my neighbor Bill from 2 properties over walked up my driveway. Bill was a retired teacher in his 60s who had always been friendly and often bought eggs and vegetables from me. "Hey, Harrison," he called out, waving. "Got a minute? Sure, what's up?" I walked over to meet him. Bill looked uncomfortable. "I wanted to give you a heads up about what's going on. Brenda Morrison has been on a warpath lately. She moved into the development about 6 months ago, took over as HOA president almost immediately, and she has been trying to turn this place into some kind of perfect suburban paradise. She has been sending violation notices to half the neighborhood about things like mailbox colors and lawn ornaments. "Why is she targeting me?" I asked. "Because your property does not fit her vision," Bill said bluntly. "She has been talking about how this area should be upscale, how property values need to be protected, and how anything that looks too rural or agricultural brings down the neighborhood. She actually said at the last HOA meeting that your farm makes the development look like it is in the middle of nowhere." I felt my jaw clench. This land was here first. The development was built around existing properties, including mine. "I know that, and most of the neighbors know that too," Bill assured me. "But Brenda does not care. She wants what she wants, and she is willing to use the HOA to get it. I just wanted to warn you that she is not going to back down easily. She has already been talking about taking you to court if you do not comply." After Bill left, I sat on my porch and thought about my options. I could give in and stop my early morning work, but that would mean my animals would suffer. I could get rid of the animals entirely, but that would mean giving up the lifestyle I had worked hard to build. Or I could fight back and hope that the law was really on my side. I chose to fight. The next day, I drove into Lancaster and met with a lawyer named Robert Chen who specialized in agricultural law. Robert was in his late 30s, sharp-eyed and serious, and he listened carefully as I explained the situation. "You have copies of all the documents?" he asked when I finished. I handed him the folder I had brought containing the HOA notice, my property deed, the HOA covenants, and the zoning confirmation from the county. Robert spent 20 minutes reading through everything, making notes on a legal pad. Finally, he looked up and smiled. "This is actually a fairly straightforward case," he said. "Pennsylvania has strong right to farm protections. The law specifically states that agricultural operations cannot be deemed a nuisance if they have been in operation for more than 1 year, and if they comply with standard agricultural practices. Your farm meets both criteria." "So the HOA cannot stop me?" I asked. "They can try, but they will lose," Robert said confidently. "The Right to Farm Act supersedes HOA covenants when it comes to legitimate agricultural activities. Moreover, your property is zoned agricultural, which means you have the legal right to conduct farming operations. The HOA cannot override county zoning. What about their fines and threats to put a lien on my property?" "Empty threats, legally speaking," Robert said. "They cannot enforce fines for activities that are protected under state law. If they try to place a lien, we can challenge it in court and have it removed. In fact, if they continue to harass you, we might have grounds for a countersuit." I felt relief wash over me. "So what do I do now?" "Let me draft a response to their notice," Robert said. "I will cite the relevant statutes and make it clear that their demands are legally unenforceable. That might be enough to make them back down. If not, we will be prepared to take this to court." 2 days later, Robert sent a detailed legal response to the HOA that laid out exactly why their demands were invalid. He cited the Pennsylvania Right to Farm Act, the county zoning regulations, and several court precedents where HOAs had lost similar cases. The letter was polite but firm, and it made clear that I had no intention of changing my farming practices, and that any attempt to fine me or place a lien on my property would be met with legal action. I honestly thought that would be the end of it. I expected the HOA to realize they were on shaky legal ground and back off. I was wrong. 3 days after Robert sent his letter, I received another notice from the HOA. This one was even more aggressive. It stated that my legal response had been reviewed and rejected, that the HOA stood by its position, and that fines would begin accruing immediately. Furthermore, the notice stated that the HOA board had voted to pursue all available legal remedies, including seeking an injunction to stop my farming activities. I called Robert immediately. "They are not backing down," I told him. "They are doubling down." "Then we go to court," Robert said simply. "File a declaratory judgment action to establish your rights under the Right to Farm Act. We will also seek an injunction preventing them from interfering with your agricultural operations. Can you meet me tomorrow to start preparing?" Over the next week, Robert and I worked on building our case. He gathered more documentation about the Right to Farm Act, collected statements from agricultural experts about standard farming practices, and prepared affidavits about the history of agricultural use on my property. I provided detailed records of my farming activities, including feeding schedules, animal care logs, and even noise measurements I had taken myself to show that my farm was not excessively loud. We also discovered something interesting. Robert filed a public records request with the HOA and obtained copies of all the noise complaints that had allegedly been filed against me. Every single complaint had come from the same address, Brenda Morrison's house. There were no complaints from any other residents. Brenda had essentially fabricated a widespread problem to justify her personal vendetta against my farm. "This is good for us," Robert said when we reviewed the complaint records. "It shows that this is not really about noise or disturbing the peace. This is about one person trying to use the HOA to force you out." We filed our lawsuit in the Lancaster County Court of Common Pleas, seeking a declaratory judgment that my farming activities were protected under state law, and an injunction preventing the HOA from interfering with those activities. The HOA responded by filing their own lawsuit seeking an injunction against me, claiming that my farm was a nuisance and a violation of the community covenants. The judge assigned to the case was the Honorable Patricia Ramsey, a no-nonsense jurist in her 50s with a reputation for cutting through legal nonsense and getting to the heart of issues quickly. She scheduled a preliminary hearing for 2 weeks out to address the competing injunction requests. In the meantime, my life became increasingly difficult. The HOA began fining me $500 per day, as promised. I did not pay the fines, but the notices kept coming, and the amount allegedly owed kept climbing. Brenda Morrison started showing up at my property at random times, always with a camera, documenting what she claimed were violations. She would stand at the edge of my property line, recording video of me doing ordinary farm work and shouting questions like, "Do you think your neighbors enjoy being woken up by your animals? And how much longer are you going to torture this community?" I tried to ignore her, but it was harassment, plain and simple. Other neighbors started coming by to show their support. Bill brought me a casserole and told me that several residents were furious about how Brenda was acting. A woman named Susan from 3 doors down brought a petition signed by 25 households stating that they had no problem with my farm and actually valued having fresh eggs and produce available locally. "Brenda is making herself very unpopular," Susan told me. "She has been sending violation notices to everyone about the pettiest things. Last week, she told the Johnsons they had to repaint their shutters because the color was not on the approved list, even though their shutters have been that color for 10 years. People are fed up." The support from my neighbors was encouraging, but it did not change the legal reality. I still had to defend myself in court, and that was expensive. Robert was good about keeping his fees reasonable, but legal work was not cheap, and the costs were adding up quickly. The day of the preliminary hearing arrived cold and rainy. I put on my best suit, which felt strange after weeks of wearing work clothes, and drove to the courthouse with Robert. We arrived early and found seats in the courtroom while we waited for the case to be called. Brenda Morrison arrived with an attorney, a slick-looking guy in an expensive suit named Philip Garrett, who apparently specialized in HOA law. They sat on the opposite side of the courtroom, and Brenda kept shooting hostile glances in my direction. She was dressed like she was going to a country club, all designer labels and jewelry. When our case was called, we all stood and approached the bench. Judge Ramsey looked over the filings with a skeptical expression. "Let me make sure I understand what we have here," she said, looking first at the HOA attorney. "Mr. Garrett, your client wants this court to issue an injunction preventing Mr. Fletcher from conducting farming activities on his property before 7 in the morning. Is that correct?" "Yes, Your Honor," Garrett said smoothly. "Mr. Fletcher's activities are creating a nuisance that violates the community covenants and disturbs the peaceful enjoyment of other residents. And Mr. Chen, your client argues that his farming activities are protected under the Pennsylvania Right to Farm Act and cannot be restricted by the HOA. Correct?" "That is correct, Your Honor," Robert said. "Moreover, Mr. Fletcher's property is zoned agricultural and has been used for farming for over 50 years. The HOA has no legal authority to restrict legitimate agricultural operations." Judge Ramsey nodded slowly. "Mr. Garrett, I have reviewed the Pennsylvania Right to Farm Act. Are you familiar with this statute?" "Yes, Your Honor, but we believe it does not apply in this case because Mr. Fletcher's activities go beyond what is protected under the Act." "How so?" the judge asked, her tone suggesting she was not convinced. Garrett pulled out a folder and began reading from it. "The Act protects normal agricultural operations, but Mr. Fletcher's rooster crows as early as 4:30 in the morning. This is excessive and unreasonable. Furthermore, he uses metal equipment that creates loud banging noises that echo through the neighborhood." Judge Ramsey turned to Robert. "Mr. Chen, what is your response?" "Your Honor, roosters crow at dawn. That is what roosters do. It is a normal part of agricultural operations. As for the so-called loud banging noises, Mr. Fletcher uses standard farming equipment like any farmer would. We have noise measurements showing that the sound levels from his property are well within acceptable ranges and are consistent with agricultural use. Furthermore, we have obtained records showing that all of the noise complaints came from a single individual, Mrs. Morrison herself. There are no complaints from any other residents. In fact, we have a petition signed by 25 households stating that they have no issue with Mr. Fletcher's farm." Garrett interrupted. "Your Honor, whether one person or 100 people complain is irrelevant. The HOA covenants prohibit activities that create nuisances, and Mr. Fletcher is in violation. Except that the Right to Farm Act specifically states that agricultural operations cannot be deemed nuisances," Robert shot back. "The Pennsylvania legislature made a policy decision that farming is important and should be protected from exactly this type of complaint. HOA covenants cannot override state law." Judge Ramsey held up her hand. "Gentlemen, I have read the briefs. Mr. Garrett, I am going to be frank with you. Based on the law as I understand it, your client has a very weak case. The Right to Farm Act is clear, and Mr. Fletcher's property is zoned for agricultural use. Unless you can show me why the Act does not apply here, I am inclined to rule in Mr. Fletcher's favor." Garrett looked flustered. "Your Honor, the Act is meant to protect farmers from unreasonable complaints, but there must be limits. Mr. Fletcher chose to buy property in a residential development. He should have to conform to community standards. He bought property that was already zoned agricultural, and was already being used for farming, Robert countered. The development was built around his property, not the other way around. He has every right to continue the agricultural use that existed before the development was even there. Judge Ramsey studied the documents in front of her for a long moment, then looked up. I am going to deny the HOA's request for an injunction. Mr. Fletcher has demonstrated that his activities are protected under the Pennsylvania Right to Farm Act and are consistent with the agricultural zoning of his property. The HOA cannot use its covenants to prohibit activities that are explicitly protected by state law. I felt a surge of relief so strong I almost laughed out loud, but the judge was not finished. However, I am also going to deny Mr. Fletcher's request for an injunction at this time. I want to see this case proceed through discovery and hear full arguments before I issue any permanent orders. But let me be clear, Mrs. Morrison, she said, looking directly at Brenda. Based on what I have seen so far, you are fighting an uphill battle. The law strongly favors agricultural operations in situations like this. I suggest you consider whether continuing this litigation is really in your best interest. Brenda's face turned red, but she did not say anything. Judge Ramsey set a schedule for discovery and a trial date 4 months out, then dismissed us. As we left the courtroom, Robert clapped me on the shoulder. That went well. The judge basically told them they are going to lose. So why did not she just rule in our favor completely? I asked. Because judges like to see the full case before issuing permanent orders, Robert explained. But her comments from the bench are a good sign. The HOA would be smart to drop this now. We walked out of the courthouse into the rain. Across the parking lot, I could see Brenda Morrison arguing with her lawyer, her arms waving dramatically. She looked furious. I do not think she is going to drop it, I said. Then we will beat her in court, Robert said confidently. Over the next few weeks, I continued my normal farming routine, and the HOA continued sending me violation notices and adding to the alleged fines I owed. The amount had climbed to over $15,000, a ridiculous sum that I had no intention of paying. Robert assured me that the fines were unenforceable, but seeing the numbers climb was still stressful. The discovery phase of the lawsuit began, which meant both sides had to exchange documents and information. Robert subpoenaed HOA records, meeting minutes, and communications related to my property. What came back was revealing and disturbing. It turned out that Brenda Morrison had been planning her campaign against my farm for months. The HOA meeting minutes showed that she had raised the issue of my farm repeatedly, calling it an eyesore and claiming it was bringing down property values. Several board members had pushed back, noting that my farm was legal and that most residents had no complaints, but Brenda had been persistent. She had even hired an appraiser to evaluate whether my farm was affecting property values in the development, though the appraiser's report concluded that there was no negative impact. Even more interesting were Brenda's personal communications. As part of discovery, Robert had requested all emails and text messages related to the dispute. Brenda's emails to her lawyer showed that this was not really about noise or nuisances at all. In one email, she wrote, "I did not pay $700,000 for a house in this development to look out my window and see goats and chickens. Harrison Fletcher needs to understand that his little farm is not appropriate for this neighborhood, and I will do whatever it takes to make him leave." Another email was even more damning. Brenda had written to a friend, "If I can make life difficult enough for him, he will eventually sell and move somewhere more appropriate for his barnyard operation. I am going to use every tool the HOA has to make him miserable." When Robert showed me these emails, I felt both vindicated and angry. This proves that she is harassing me on purpose. It absolutely does, Robert agreed. And it is going to be very helpful at trial. It shows bad faith and abuse of the HOA's authority. We might even have grounds for a harassment claim or a claim for abuse of process. But despite the strong evidence in our favor, Brenda Morrison showed no signs of backing down. In fact, she escalated her campaign. She started attending township meetings and complaining to local officials about my farm, claiming that I was violating various regulations. Each complaint triggered an inspection, and though I was always found to be in compliance, the constant scrutiny was exhausting. She also ramped up her personal harassment. She began showing up at my property almost daily, always with her camera, always making snide comments and accusations. One morning, I came out to find that someone had spray-painted "Farms Don't Belong Here" on my mailbox. I could not prove it was Brenda, but the timing was suspicious. I reported the vandalism to the police, and they took a report, but without evidence of who did it, there was not much they could do. I installed security cameras around my property after that, which turned out to be a wise decision. 2 weeks later, my cameras caught Brenda Morrison creeping onto my property at 6 in the morning. She walked right up to my chicken coop and started banging on the metal walls, clearly trying to rile up the chickens and create noise. Then she walked back to the edge of my property and used her phone to record video of the now squawking chickens, as if to document the noise problem she had just created. I was stunned when I watched the footage. This was not just harassment anymore. This was trespassing and evidence tampering. I immediately sent the video to Robert. "This is unbelievable," Robert said when he called me back. "She is manufacturing evidence. This is going to destroy her credibility in court." "Should I go to the police?" I asked. "Absolutely," Robert said. "File a trespassing complaint and show them this video. We will also submit this as evidence in the lawsuit." I went to the police station that afternoon and filed a formal complaint against Brenda Morrison for trespassing. The officer who took my report watched the video and shook his head in disbelief. "Some HOA people really take things too far," he muttered. "I will go talk to her and issue a warning. If she comes onto your property again, call us immediately and we can pursue charges." The officer went to Brenda's house that evening. I was not there, obviously, but according to Bill, who heard about it through the neighborhood grapevine, Brenda had answered the door and immediately started ranting about how I was the problem and how the police should be investigating me, not her. The officer had apparently told her in no uncertain terms that she had committed trespassing, that she needed to stay off my property, and that if she continued to harass me, she could face criminal charges. I hoped that would be the end of her personal harassment, and for the most part, it was. Brenda stopped coming onto my property, though she still glared at me whenever our paths crossed in the neighborhood. The legal case moved forward. Robert deposed Brenda, and according to him, it did not go well for her. She was defensive and combative, and when confronted with her emails about wanting to drive me out of the neighborhood, she tried to claim they were taken out of context. Robert also deposed several of my neighbors, who testified that they had no problems with my farm, and that Brenda had been acting erratically since becoming HOA president. We were preparing for trial when something unexpected happened. The HOA held its annual meeting and board election. I did not attend, assuming it would just be more of the same, but the next day, Bill came by with news. "Brenda got voted out," he said with a huge grin. "The residents were fed up with her constant violation notices and harassment. Someone ran against her for president, and it was not even close. She lost by a landslide." "Who is the new president?" I asked. a guy named Tom Henderson. He is reasonable, and he already said at the meeting that the HOA needs to focus on real issues, not petty complaints. He also said he thought the lawsuit against you was a waste of HOA funds and that the board should consider settling. This was encouraging news, but I was not ready to celebrate yet. Just because Brenda was no longer HOA president did not mean the lawsuit would go away. The HOA itself was still the plaintiff, and they would have to vote to drop the case. A week later, I received a call from Robert. The HOA's lawyer just reached out to me. They want to discuss a settlement. What kind of settlement? I asked cautiously. That is what we need to find out. Are you willing to meet with them? Yes, but I am not giving up my farm, I said firmly. I would not advise that anyway, Robert said. Let us see what they have to say. The settlement meeting was held at Robert's office. Representing the HOA were their attorney Philip Garrett, the new HOA president Tom Henderson, and 2 board members. Brenda Morrison was not present, though I had no doubt she would be furious when she found out about this meeting. Tom Henderson started the conversation. Mr. Fletcher, I want to apologize on behalf of the HOA for how this situation has been handled. The previous board, under Mrs. Morrison's leadership, pursued this case without properly considering the legal ramifications or the will of the residents. After reviewing everything, the current board believes this lawsuit is without merit and is not in the best interest of the community. I nodded, waiting to hear where this was going. We would like to propose a settlement, Tom continued. The HOA will drop all claims against you, withdraw all fines and penalties, and issue a formal acknowledgement that your farming activities are legal and protected under state law. In exchange, we ask that you agree to some reasonable accommodations to minimize any potential disturbance to neighbors. What kind of accommodations? I asked. Philip Garrett spoke up. Nothing that would interfere with your farming operations. We are talking about things like maintaining vegetative buffers between your property and neighboring homes, perhaps installing some soundproofing materials in the areas where you use equipment, and agreeing to a communication protocol so that if any neighbor has a concern, they can bring it to you directly before involving the HOA. Robert leaned forward. And what about the legal fees Mr. Fletcher has incurred defending himself against a baseless lawsuit? Tom winced. That is a difficult issue. The HOA's funds come from resident dues, and we do not have a large reserve. But we recognize that Mr. Fletcher should not have to bear the cost of defending his legal rights. We are prepared to offer $15,000 toward his legal expenses. Robert and I exchanged glances. Can we have a moment to discuss this privately? Robert asked. Tom nodded, and the HOA representative stepped out of the office. Once we were alone, Robert said, "What do you think?" "I want to be done with this," I admitted, "but I do not want to agree to restrictions that will make it harder for me to farm." "The accommodations they are proposing are pretty minimal," Robert said. "Vegetative buffers are actually good for you because they provide more privacy. Soundproofing materials might be a minor expense, but nothing major. And the communication protocol is just common sense. As for the money, $15,000 is probably about half of what you have spent on legal fees, but it is better than nothing, and it means you do not have to go to trial." "What if Brenda challenges this settlement?" I asked. "She cannot," Robert said. "She is no longer on the board. The current board has the authority to settle litigation. If she does not like it, her only recourse would be to try to sue the HOA itself, which would be expensive and unlikely to succeed." I thought about it for a minute, weighing my options. I could reject the settlement and go to trial, where we would probably win, but that would mean more months of stress, more legal fees, and more uncertainty. Or I could accept this settlement, Get the HOA off my back and go back to living my life. Let us accept it, I said finally. But I want the settlement to be absolutely clear that they cannot bring future claims about my farming activities. Robert nodded. I will make sure the language is ironclad. We called the HOA representatives back in and told them we would accept the settlement terms, subject to review of the final agreement. Over the next week, Robert and Philip Garrett went back and forth on the specific language, making sure everything was clear and enforceable. The final settlement agreement included a complete dismissal of all claims against me with prejudice, meaning they could never be brought again, withdrawal of all fines and penalties, with confirmation that I owed the HOA nothing, a formal acknowledgement that my farming activities were legal, protected under state law, and could not be restricted by HOA covenants. My agreement to maintain vegetative buffers and use reasonable efforts to minimize noise, though with explicit language stating that normal farming noises were acceptable. A $15,000 payment to me for legal expenses. A mutual non-disparagement clause, meaning neither side could publicly trash-talk the other. The HOA board voted to approve the settlement at their next meeting. According to Bill, who attended, Brenda Morrison showed up and went on a furious tirade about how the board was betraying the community and how I was getting away with ruining the neighborhood. Several residents shouted her down, and Tom Henderson had to threaten to have her removed from the meeting if she did not calm down. The settlement was finalized and signed in mid-August, nearly 6 months after Brenda had first shown up at my farm with her clipboard. The HOA's check arrived a few days later, and Robert filed the dismissal paperwork with the court. I thought that would be the end of it. I was wrong again. 2 weeks after the settlement was finalized, I was working in my garden when a sheriff's deputy pulled up to my house. My heart sank, wondering what fresh hell this could be. "Harrison Fletcher?" the deputy asked as he got out of his car. "That is me," I said, pulling off my work gloves. "I need to talk to you about Brenda Morrison," the deputy said. "Are you aware that she has been spreading false information about you on social media?" I blinked in surprise. "No, I am not on social media much. What is she saying?" The deputy pulled out his phone and showed me screenshots. Brenda had created posts on Facebook and a local community forum claiming that I was running an illegal farm, that I had been fined thousands of dollars by the HOA, and that I was mistreating my animals. She had even posted photos of my property that she must have taken with a telephoto lens from outside my property line. "The reason I am here is that several of your neighbors reported these posts, and someone from the county animal control office saw them and asked us to check it out," the deputy explained. "I am required to investigate any allegations of animal mistreatment." "My animals are well cared for," I said, feeling my temper rise. "You are welcome to inspect my property and see for yourself." "I appreciate that," the deputy said. "Would you mind showing me around?" I spent the next 30 minutes walking the deputy through my farm, showing him the animal enclosures, the feed storage, my care logs, and veterinary records. He took notes and photos, and at the end, he seemed satisfied. "Everything looks good here," he said. "Your animals are clearly healthy and well cared for. I will file a report stating that the allegations were unfounded." "What about Brenda Morrison?" I asked. "She is violating our settlement agreement by disparaging me, and she is making false statements." "That is a civil matter between you and her," the deputy said. "But I would suggest documenting everything she is posting. If her statements are provably false and damaging to you, you might have grounds for a defamation lawsuit." After the deputy left, I called Robert and told him what had happened. He was furious. "She is in clear violation of the settlement," he said. "We can haul her into court for contempt and potentially sue her personally for defamation. Start taking screenshots of everything she has posted." I spent the evening documenting Brenda's social media campaign. It was extensive. She had made dozens of posts over the past 2 weeks, each one more inflammatory than the last. She was claiming I was a menace to the community, that my farm was illegal, that I had attacked her, and various other lies. Some of the posts had been shared widely, and people who did not know me were commenting about what a terrible person I was. Robert filed a motion to hold Brenda in contempt of the settlement agreement, and we also filed a defamation lawsuit against her personally. The contempt motion was heard quickly, and the judge was not pleased. Judge Ramsey, who had handled our original case, called Brenda into court. "Mrs. Morrison, do you understand what a non-disparagement clause means?" the judge asked, her tone icy. "Yes, Your Honor, but I have a right to free speech," Brenda said defiantly. "You have a right to free speech, but you do not have a right to violate a court-approved settlement agreement," Judge Ramsey said. "You agreed not to disparage Mr. Fletcher, and you have done exactly that. Moreover, you have made false statements about him, which is not protected speech. I am finding you in contempt and ordering you to immediately remove all social media posts about Mr. Fletcher. You are also ordered to post a public retraction and apology. If you violate this order, you will face fines and possible jail time." Brenda's face went pale. "Your Honor, I am not finished," the judge said. "You are also ordered to pay Mr. Fletcher's legal fees for bringing this contempt motion. That comes out of your personal funds, not HOA funds. Do you understand?" "Yes, Your Honor," Brenda said quietly, all her earlier defiance gone. The defamation lawsuit took longer to resolve, but ultimately, Brenda's insurance company decided to settle rather than go to trial. They paid me $50,000 and required Brenda to sign an agreement prohibiting her from ever making any statements about me or my farm again. If she violated that agreement, she would owe me an additional $100,000. By the time everything was finally resolved, it was early November. The legal battles had consumed most of the year, cost me significant stress and money, and exposed just how vindictive and unreasonable some people could be. But I had won. My right to farm was firmly established. The HOA could not interfere with my operations, and Brenda Morrison had been held accountable for her harassment. I continued my farming routine, waking up at 4:30 every morning to care for my animals, just as I had always done. The new HOA board was professional and reasonable, and we had no further conflicts. Several neighbors even started buying eggs and vegetables from me regularly, and I became something of a local fixture at the farmers' market. Bill stopped by one crisp Saturday morning in late November, just as I was finishing my chores. "Thought you would want to know," he said. "Brenda Morrison put her house up for sale. Looks like she is moving." I felt a mixture of emotions at that news. Part of me was relieved that she would be gone, and I would not have to worry about running into her. But part of me also felt sad that it had come to this. If Brenda had just accepted that different people want to live different ways, none of this would have been necessary. "Where is she going?" I asked. "Apparently some gated community in Florida," Bill said. "The kind of place where everything is perfectly manicured and controlled, probably a better fit for her." "I hope she is happier there," I said, and I meant it. Brenda's misery had made her lash out at me, and I did not wish that kind of unhappiness on anyone. As winter set in, and my farm settled into its quieter season, I reflected on everything that had happened. The experience had taught me important lessons about standing up for my rights, the importance of good legal representation, and the reality that not everyone is going to approve of your lifestyle choices. But it had also shown me the value of good neighbors, the strength of community support, and the wisdom of laws that protect important activities like farming. My rooster still crowed at dawn every morning. My goats still bleated for their breakfast at 5. And I still went out in the cold pre-dawn darkness to do the work that needs doing on any farm. But now, I did it with the confidence that the law was on my side, and that my right to farm was firmly protected. The Pennsylvania Right to Farm Act had been written precisely for situations like mine, to prevent urban sprawl and residential development from pushing out agricultural operations that had existed long before the subdivisions arrived. The legislators who wrote that law understood that farming is more than just a business or a hobby. It is a way of life and an essential part of our food system. They understood that farms cannot operate on a 9-to-5 schedule, that animals need care when they need it, and that the sounds and smells of agriculture are not nuisances, but signs of productive land being used as it should be. My case set a precedent in Lancaster County. Robert told me that several other farmers facing similar HOA disputes had reached out to him after reading about my case in the local paper. In each instance, the mere mention of the Right to Farm Act and the outcome of my lawsuit had been enough to make the HOAs back down. No one wanted to spend thousands of dollars on legal fees only to lose, as Brenda Morrison and the Meadowbrook Springs HOA had done. The following spring, I expanded my farm slightly, adding some beehives and a small orchard. The new HOA board had no objections, and several neighbors came by to watch me install the hives and to learn about beekeeping. It turned out that many people in the development were interested in where their food came from and appreciated having a working farm in their community. I also started offering farm tours for local school groups. Kids would come out to see the chickens and goats, learn about where eggs come from, and get a glimpse of agricultural life. It was rewarding to see their excitement, and to know that I was helping educate the next generation about the importance of farming. Tom Henderson, the HOA president who had helped negotiate the settlement, became a regular customer and something of a friend. He told me that one of his goals as president was to make the HOA focus on things that actually mattered to residents, like maintaining common areas and organizing community events, rather than policing every minor violation of arbitrary rules. Brenda had turned the HOA into this oppressive force that everyone resented. Tom said one day while buying eggs, people were afraid to put up Christmas decorations or plant flowers without checking the covenants first. That is not what an HOA should be. We are supposed to help maintain property values and build community, not make people miserable. Under Tom's leadership, the HOA revised many of its rules, eliminating petty restrictions and focusing on genuine community concerns. The result was a much happier neighborhood. People felt like they could actually enjoy their homes rather than constantly worrying about violation notices. As for Brenda Morrison, she moved to Florida in January, and I never saw her again. I heard through the neighborhood grapevine that she had gotten involved with her new HOA down there and was already making enemies with her rigid enforcement of rules. Some people never learn. Looking back on the whole experience, I realized that it had changed me in some fundamental ways. Before Brenda's campaign against me, I had been content to keep to myself, do my farming, and not get involved in community affairs. The legal battle had forced me out of that comfortable isolation and made me engage with my neighbors, the legal system, and local government. I had learned that sometimes you have to fight for what is right, even when it is expensive and stressful and consumes your life for months. I had also learned to appreciate the quieter victories. Every morning when I walked out to feed my animals and saw the sun rising over my fields, I felt grateful for the right to live this life I had chosen. Every egg I collected, every vegetable I harvested, every satisfied customer at the farmer's market was a small affirmation that I was doing something worthwhile. The legal documents from my case stayed in a file in my office, a reminder of what I had been through. But I did not need to look at them often. The real evidence of my victory was all around me. The healthy animals, the productive garden, the supportive neighbors, and the peaceful routine of farm life that continued day after day, undisturbed by unreasonable HOA demands. One morning in early May, about a year after the settlement, I was out feeding my chickens when a car pulled into my driveway. For a moment, I felt that old anxiety return, wondering if this was another problem. But the driver who got out was a young man in his late 20s with a friendly smile. "Are you Harrison Fletcher?" he asked. "I am," I said cautiously. "My name is David Franklin. I am looking at buying some land in the area to start a small farm, and someone at the farmer's market told me I should talk to you. They said you had dealt with HOA issues and might have some advice." I smiled, feeling the tension drain away. "I've got some experience with that. Come on, let me show you around and we can talk." We spent the next hour walking my property while I told David about my experiences and what I had learned. I explained the importance of checking zoning regulations, understanding the Right to Farm Act, and getting good legal advice early if problems arose. I showed him my farm setup and shared tips about raising chickens and goats. By the end of the conversation, David was excited and grateful. "You have really built something great here," he said. "I hope I can do the same." "You can," I assured him. "Just remember that farming is not just about the work. It is about understanding your rights, building relationships with your neighbors, and standing your ground when necessary." After David left, I went back to my work, but I felt good about the conversation. Maybe some good had come from my ordeal with Brenda Morrison after all. If my experience could help other farmers protect their rights and avoid similar harassment, then perhaps all that stress and expense had been worth it. As the seasons continued their eternal cycle and my farm flourished, I found a deep contentment in the life I had fought so hard to protect. The early morning hours that Brenda Morrison had found so objectionable became even more precious to me. There was something magical about being awake and working while the rest of the world slept, about seeing the sky gradually lighten and the day begin, about being part of the ancient rhythm of agricultural life that had sustained humanity for thousands of years. My lawyer Robert became a friend, and we stayed in touch. He told me that he now included my case as an example when teaching seminars on agricultural law. The story of one farmer standing up to an overreaching HOA and winning had become a teaching moment for other lawyers and farmers across Pennsylvania. The $15,000 I received from the HOA settlement and the $50,000 from Brenda's defamation settlement helped offset my legal costs and provided funds for improvements to my farm. I installed a new irrigation system for my garden, upgraded my chicken coops with better ventilation and predator protection, and built a proper barn for my goats. These improvements made my farm more efficient and allowed me to increase production, which in turn increased my income. More importantly, the money represented justice. It was acknowledgement that I had been wronged and that those who had wronged me had to pay a price. That mattered more than the dollar amount. The County Agricultural Extension Office asked me to speak at a workshop for new farmers about legal issues and protecting farm rights. Standing in front of a room of aspiring farmers, sharing my story and the lessons I had learned. I felt a sense of purpose beyond just running my own farm. I was contributing to a broader movement to preserve agricultural land and farming as a way of life. During the presentation, a woman raised her hand. "Were you ever tempted to just give up and sell?" she asked. I thought about that question carefully before answering. "Yes," I admitted. There were days when the stress felt overwhelming and I wondered if it was worth it. But then I would go outside and do my morning work, and I would remember why I started farming in the first place. This is not just a business for me. It is who I am. Giving up would have meant letting someone else dictate how I live my life, and I was not willing to do that. The room was quiet for a moment, then someone started clapping, and soon everyone joined in. I felt my face flush with embarrassment but also with pride. I had stood up for something important, and people recognized that. The years that followed were peaceful and productive. My farm became an established part of the community, a place where people could connect with where their food came from and experience a bit of agricultural life. I hired a part-time helper, a teenager from the neighborhood named Marcus, who was interested in farming and needed work. Teaching him the skills and knowledge I had accumulated over the years was deeply satisfying. The HOA under Tom Henderson's leadership became a model for how these organizations should operate. They focused on maintaining common areas, organizing community events like holiday parties and summer barbecues, and mediating disputes between neighbors. They did not waste time and money on petty enforcement actions or trying to control aspects of residents' lives that did not affect anyone else. I served on a committee that revised the HOA covenants to explicitly recognize the right to farm for agricultural properties within the development. The new language made clear that farming activities were not only permitted, but valued as part of the community's character. It was satisfying to know that future farmers in the development would not face the harassment I had endured. One evening, about 3 years after my legal battle ended, I was sitting on my porch watching the sunset when Bill walked over with a 6-pack of beer. "Thought you might want some company," he said. "Always," I replied, taking one of the beers he offered. We sat in comfortable silence for a while, watching the sky turn orange and purple. My goats were settling down for the night, making soft, contented sounds. A few chickens that had not yet gone into the coop were pecking around the yard. "You know," Bill said eventually, "when Brenda started her crusade against you, a lot of us were worried. We thought you might lose or that you would sell and move away. This neighborhood is better because you stayed and fought." "I could not have done it without support from neighbors like you," I said honestly. "That petition Susan organized, the people who testified that they had no problem with my farm, all of that mattered." "That is what community is supposed to be about," Bill said. "People supporting each other, not tearing each other down." We talked for a long time that evening about farming and neighborhood politics and life in general. As darkness fell and the stars came out, I felt a profound sense of gratitude for where I was and what I had. The legal battle with Brenda Morrison had been difficult, but it had led to something valuable. A deeper connection to my community, a clearer understanding of my rights, and an unshakable confidence that I was living the life I was meant to live. My rooster would crow again at dawn tomorrow, just as he had every morning for years. My goats would bleat for their breakfast, and I would be there to care for them, continuing the work that was not just my livelihood but my purpose. No HOA president with a clipboard and a bad attitude could take that away from me. The Pennsylvania Right to Farm Act had protected my right to continue the agricultural traditions that had existed on my land for generations. But more than that, it had affirmed a basic principle. that people should be free to live according to their values and pursue their chosen livelihoods, as long as they are not genuinely harming others. Brenda Morrison's discomfort with roosters and goats was not harm. It was simply a clash of lifestyles and values, and the law rightfully sided with the farmer who was doing something productive and meaningful. As I finally headed inside that night, I paused to look back at my farm. The barn and coops were dark silhouettes against the starry sky. The fields and garden beds lay quiet, resting and gathering strength for the next growing season. Everything was peaceful and right. This was my home. This was my life, and I had fought for it and won. That knowledge sustained me through every early morning, every hard day of work, every challenge that farming inevitably brought. I was exactly where I belonged, doing exactly what I was meant to do. And somewhere in Florida, I hoped Brenda Morrison had found her own peace, in a place where every lawn was perfectly manicured and every house looked exactly the same. That was the life she wanted, and she was welcome to it. But she had learned, at considerable cost, that she could not impose her vision on everyone else. Different people need different lives, and the law protected that diversity. As I drifted off to sleep that night, my last thought was gratitude for the lawyers, judges, neighbors, and legislators who understood that farms matter, that agricultural traditions matter, and that sometimes the most important battles are fought not with weapons but with legal briefs and testimony, and the stubborn determination to defend what is right. My alarm would go off at 4:30 tomorrow morning, just as it always did, and I would get up and go to work, just as farmers had done for thousands of years. The cycle would continue, protected by law and sustained by purpose. And that was exactly how it should be.